This episode was sponsored by the Geopolitical Insight and Education Foundation. Want to find out more? Check the link in our show notes.
Welcome to another episode of Legal for Tech, the podcast. So guys, you do recognize my voice. It's always Rosie here. And as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology. And yes, it's regulation. And today I'm a bit lonely. Well, not so lonely because I'm actually joined by a guest, of course. But Jack is not here, as you can see and hear. So yeah, I'm really sad about that. But I'm actually super happy to welcome on the podcast a friend of the show, Armelle Grandjean. Hello, Armelle. Great to see you.
Hi, thank you very much for the invitation.
I'm super happy to talk to you. And I guess our listeners will even be happier because we're actually going to talk about something that's in the news right now. We're talking about the famous GEMA case that has been decided last Friday, of course. And I mean, it's been a whiplash of emotions. A lot of things have been said on LinkedIn, on the news. How does it feel now that you're here on the podcast? Would you say content with the decision?
Yeah, I think it was a great victory. Actually, the second one on our side in the AI litigation. And yeah, we are very happy and confident that we will now have more licensing in this field.
I'm super happy to start with this conversation, and I can't wait to deep dive into the meanders of this decision. But Armelle, before we really start talking about the legal side, maybe it's nice if you can tell our listeners something about you. How and why would you describe yourself as a good representative for talking about this case?
Yeah, I think I'm a good representative for talking on this case specifically because I love music and I also studied musicology besides of my legal education. And that's also the reason why I always wanted to become a lawyer in the music business and why I then specialized also in copyright law. I wrote a PhD thesis on the subject of fair remuneration of artists in the digital age, before AI, but already in the digital age. And from this subject of fair remuneration, the path was not too far to a collective management organization. And so since 2019, I have been working at GEMA, the German Musical Collecting Society. Yeah, and there I'm a legal counsel in the legal department. And for several years now, I have been dealing in particular with all these questions on AI and copyright.
Actually super nice because as our listeners know, I'm actually based in Munich and I actually know where GEMA is because I go there quite often. It's very nice to study at the Gasteig. So yeah, yeah, our listeners will understand that it's quite warm today in Munich, so we're both like really keeping it in and holding on together to actually make this recording work. But that said, I mean, we've said that the GEMA is obviously basically a management organization, but like, what do you actually do at GEMA? Why is it so important to this case that you are working at GEMA, and why was GEMA able to bring about the rights that we've been discussing alongside copyright law and stuff?
So GEMA is representing the rights of musical composers, lyricists, and music publishers. So we are licensing any use of the music of our members, and the money that we get from these licenses is then paid to our members. So we assure the fair remuneration of authors who live from their professional musical work, and they want to be able to work from this also in the age of AI, and that is threatened at the moment. So we conducted a survey, and 70% of our members and the members of our French sister society, SACEM, fear that AI content is replacing them, so that they can no longer be able to live from their work as a musical professional. And yeah, that's very interesting times and a lot of work that we have there to preserve the cultural diversity as well, because as a collective management organization, we also have the duty to give room for niche repertoires and not so many not only the big mass business mainstream, I wanted to say.
Yeah, and I mean, I really love this idea of like preservation of the cultural diversity. I think it's particularly important to the concept of music because, of course, we know that although some tunes remain popular throughout times, I would say not always what was popular in a specific time period will then remain popular throughout time. And I think that's super interesting if you think of someone like Vivaldi. I mean, of course, I'm Italian, so I'm going to talk about a great Italian composer. Yeah, I mean, he died alone in an apartment in Vienna, and at the time, probably he was maybe seen a bit niche, like at the time that he was dying, but then not at the time that he was composing. But if you think about it, I mean, if nobody protects maybe the smaller at now what we consider the smaller niche kind of creator or producer or songwriter, we'll never know what will happen in the future. And even if it doesn't happen, I mean, it's still great music, so why shouldn't it be protected, right? And I would like to let's kind of like start talking about the case, because you did say that this is a second victory, because you do preserve the cultural diversity in the musical sphere, but you don't make discrimination when it comes to protecting it against a infringement that you are noticing. Indeed, this is the second case against a second kind of AI provider. You're not just going against one, of course. The first case that was considered a victory was argued against OpenAI. Now we're talking about Suno. What's the kind of fil rouge that takes the two cases into comparison? Why did you choose to move action against these two specific AI providers? We're talking about LLMs and large sound models. And how did you bring about the cases in this case?
Yeah, maybe to start, in general, I think everyone is aware, but it's always worth to underline it again that AI models have been trained on vast amount of data and including copyright protected materials. So the web has been systematically scraped, and also copyright protected works also from the repertoire of our members has been used by AI models already in the training phase, and then it's also used in the model itself, and sometimes even in the output, which we demonstrated with our cases. So because AI providers have not been willing to get a license from us, they always said under this kind of legal gray area, this scraping, they consider it allowed under copyright law, and they simply did it without asking for any authorization by the authors or remuneration paid. So we decided that this fundamental legal questions have to be cleared by a court, and that's why we filed these lawsuits. The first one was against OpenAI because of the use of song text or lyrics in ChatGPT. We demonstrated that with simple prompts like give me the lyrics of the song XYZ, you could extract the exact lyrics from the system. And the court decided that these infringement in the output also constituted a reproduction in the model itself. And then we also filed this second lawsuit against Suno AI, a music generator tool. And we did a similar procedure then as with ChatGPT. So by a simple prompt, in this case, prompting with the lyrics, we demonstrated that Suno was able to issue outputs that were very similar to original songs of our members. So subject to the lawsuit are 6 concrete songs, for example, 70s disco pop iconic songs like Daddy Cool or Rasputin by Boney M, or also 80s disco songs by Alphaville, for example, Big in Japan or Forever Young. You can also hear these sound examples on our website, and they have also been heard during the oral hearing, real hearing of evidence in the courtroom. So everyone was able to see that this were really bad cover versions of the original version. And we claimed several copyright infringements, reproduction and communication to the public of the songs because they are issued in the output, and reproduction in the model itself. And the third infringement that we claimed in the Suno case, this wasn't yet the case for OpenAI, is that we also claimed training procedures that took place on the US territory in the case of Suno, and therefore they are subject to US copyright law due to the principle of territoriality, which governs international copyright law or the applicable law. Yes, and this have been our claims. And as you said, we have a decision now that affirmed all these 3 copyright infringements.
Just to clarify also with our listeners, in case not everyone is familiar with copyright law, because it's a very peculiar branch of law. When we go on Google, for example, and there are also other search engine available, of course, but say that we go on Google, we search, okay, I want to know the text of Halo, say from Beyonce, text comes out, and that's not a copyright infringement. But then if I ask, say, if I prompt ChatGPT, just because your case was against OpenAI, but of course other models are available and other providers are available, in that case, it becomes an infringement. What's the difference between these 2 processes, and why is one an infringement and the other isn't?
A copyright infringement is always there if the work is reproduced or communicated to the public, and the mere reading of a book or listening to music, what a human does, is not a copyright relevant act. But if you then redistribute it by a reproduction or something else to a further public, then this is a copyright relevant act. And in the case of these AI models, what the Munich Regional Court here has decided is that there is a communication to the public when users can issue an original work by prompting. And the court also made clear that the provider is liable for this infringement. So it's not the individual user prompting who is liable for this copyright infringement, but it's the AI provider, because he has the control over the architecture of his system. He selected the training data and is responsible for the algorithms. So that's a clear copyright infringement by the AI provider here.
Yes, of course. And as you said at the beginning of our conversation as well, there's a whole issue of licensing, of course, which is what really kind of is also, I would say, behind the idea of an infringement. So like, if you want to use my material, you probably could do it, but even in the in the internet sphere, in the digital sphere, but you have to pay licenses. As you said, that's what GEMA ultimately is concerned about, is the management and insurance that these licenses are fair towards the authors that participate in GEMA. So let's talk about, we've started talking a bit about the decision. This Suno decision was particularly interesting. I would say it confirmed in a specific sense what the OpenAI decision had started hinting at. Then it specified what's a copyright infringement in the field of the musical world and of copyright law in the field of music, which is already quite interesting because as we were kind of chit-chatting before we started recording, it is quite a unique kind of demonstration what you went through. As you said, the judges could tune on the beat of music from the 70s and 80s. And then, of course, there's this huge matter of the jurisdiction of the court and the international kind of effect of this decision, which is probably what, as you said, made the Suno decision also very interesting abroad, but also very unique when compared with the OpenAI, because you added a point when you presented the grounds for infringement as well. So let's look at the decision maybe, and let's unpack these three areas. So the similarity with the OpenAI decision, the kind of like tweak when it comes to the musical rights, and then of course the big surprise that the Court of Munich gifted us with the international jurisdiction.
Yeah, sure. The court, kind of reaffirmed its opinion that it gave in the OpenAI decision when it comes to the infringing outputs. So, as I said before, here we have musical compositions. Maybe the gathering of evidence is not as evident as it is with the lyrics, but by hearing these Suno songs, which are very similar to the original songs, the court has come to the opinion that this is an infringing output. And the court also had a look at musical scores of these songs that we issued during the procedure. So they had not only the hearing of the songs, but they also compared note by note the score of these songs, the Suno songs with the original songs. And when you have a look at these scores, there are very few difference, so it's quite the same. And that's the reason why the infringement of in the output phase was so clear. And the court also reaffirmed what it already said in the OpenAI case, that when you can issue such infringing outputs, this cannot be due to coincidence, but it is the demonstration that these original works are still in the system, even if they are only stored in the system in form of weight parameters or statistical information. But if the system is able to then issue the original song in the output, it must also be in the model. This is the so-called effect of memorization. So the works are in the machine if you are able to issue them in the output. So that was not too surprising, because it is the opinion of the court already in the OpenAI case. And they also reaffirmed that the so-called text and data mining exception does not apply to such reproduction in a model, because it can apply to training acts before if you only extract information on the work. But if the whole work is stored in the system, then this is a reproduction where the exploitation interests of authors are affected, and therefore a license is required. That was already ruled in the OpenAI case as well. And then I'm coming to the specificity of this case, what made it so impressive also internationally. It's the international aspect. So Suno has trained its system on our copyright protected material, but the training has occurred on the territory of the United States. So the servers for this training are located in the US. The training has occurred by stream ripping on YouTube, even by circumventing some technical means, the so-called rolling cipher, which is intended to prevent the downloading of works on YouTube. And the court accepted its international jurisdiction for these infringement that is based on a specific provision under the German Collective Management Organizations Act. It's a provision that allows the bundling of several infringements against a same infringing party. So we have these output claims that follow German law, and we were able to bundle them with the training claims before the same court. So that allowed the Munich Regional Court to decide over these training claims under US copyright law, because this is the applicable law to these acts which occur in the United States. And the court decided that also under US copyright law, the training was a relevant reproduction and not permitted under an exception, in particular the fair use doctrine. So in the US, we have over 100 cases on the question if AI training is allowed under US copyright law and if it is a fair use. And the German court, in our case, decided that this was not a fair use. In particular, they weighed all four factors of this fair use doctrine in our favor. In particular, they considered the use not transformative and also having relevant effects on the market. That's a fourth factor. So in our case, not least because of the infringing output, and also in particular because of the training under circumventing the rolling cipher of YouTube, the training acts were considered not being a fair use. So we have this third copyright infringement for the training acts that occurred on the territory of the United States. And I think that's a very important signal for all creators, in particular European creators, that we can enforce their rights even under a foreign legislation. And most of the AI providers are located in the United States or other territories. And we have shown that creators' rights must be respected even if training occurs outside our jurisdiction.
When we talk about enforcement, of course, I mean, there is a kind of like international convention when it comes to enforcing rulings that have been made in one country that has jurisdiction over the specific subject matter because, for example, in this case, the material was generated in Germany. So, of course, the German court had jurisdiction, but the training happened in the US. So we have two countries. We have the issue of like who is going to enforce the decision of a German court. What kind of means does the German court have when it comes to the enforcement? Can it compel OpenAI to delete any type of the material that GEMA has brought forward from its databases? Can OpenAI do it? Because I mean, we've heard a lot about, oh well, it's impossible to kind of go back to the training data. Could a German court prevent the use of OpenAI systems or of Suno systems? Of course, I'm swapping between the two here in Germany, because they are actively using some material, you know, in an illegal way, and also some material that they have apprehended in an illegal way. And we know that piracy is illegal in Germany. So how does it work? How would the court enforce this? And could GEMA kind of be in the middle when it comes to mediating this enforcement?
So in general, German court is able to enforce the decision, but only for the German part of the decision. So I think with the enforcement of the injunction for the reproductions that took place during the training phase in the US, it's not so easy to enforce this. And you also have to note that this is a first instance decision. So OpenAI already appealed the decision, and we are quite sure that also Suno will appeal the decision. Yeah, we are cautious. We are not yet enforcing such decision until we do not know how the procedure goes on, because the major goal of our litigation is not to hinder technology, and also not limited to specific cases, but we wanted to clear these fundamental legal questions to allow for a licensing market in general for our repertoire and also worldwide. And I think with these two decisions, we made a big step forward to bring these providers finally to the negotiation table, and to ensure that we have a fair licensing market, because AI systems are relying on high quality content. They need these copyright protected material. We don't want to hinder this, but we want a fair remuneration for this, so that creators can still live from their work and continue to produce content, also for the cultural diversity and so on. So I think in this regard, we did a major step. And the other side is also the political level, and we wanted to show with our litigation where maybe the legislator on national or European level, or even worldwide, where we have the need for further regulation of these AI uses.
Let's talk about that. So, like, your goals from this case, because of course, as you said, this is a first instance case. There will be an appeal, most likely. So this is just like, as you said, probably first step. It does send a signal to the political world, especially in Germany, but also, I mean, worldwide. It definitely sends a signal to the US, because it's like, well, we're not just letting you do as you please. We also have legal opinions here. But in terms of like what your goals for this whole litigation process were, would you say that this, as you said, there are parts of this decision that will definitely be viewed as positive from GEMA, but what were you hoping to achieve really? Were you hoping to achieve an injunction, or are you hoping to achieve something more, some kind of mediation, communication, and at the end, probably fair remuneration?
I think with the concrete lawsuit, we couldn't have hoped for more. We have completely been confirmed in our position that these acts are copyright relevant in the training phase, in the model itself, and then in the output. So for the cases, we couldn't have hoped for more. But yes, as I said before, the cases are only one element of our whole strategy, what we want, how we want to achieve a fair remuneration or a fair system, so that human creators are still remunerated and not replaced by AI slop in the future. So, and in this regard, both decisions are a great step, and we will continue then to reinforce now our licensing activities. And I think AI providers have seen these decisions as well, and they are under even more pressure now to come to the negotiation table.
I really like your point of view of like trying to get them to the negotiation table. I find it very interesting how like Europe is moving in a specific direction, which is rather, I would say, conservative, not in the sense that, you know, right wing, but in the sense of like trying to preserve the cultural heritage and the cultural, as you said, diversity of the European musical environment, but as well of the probably literary one. Maybe there will be decisions also on that side. Um, are you relatively, I would say, scared or like concerned of the fact that other jurisdictions may decide in a different way? Because if I'm not mistaken, today a decision from the court of, I want to say, New Delhi, so I think it's India.
Yeah.
Okay, good. Okay, thank you. Wasn't the only one. I think the decision was something along the lines of like, yes, in favor of fair use in a US kind of understanding. They cited Bart's v. Anthropic and other cases as well. Are you a bit concerned that the German kind of material is going to be downgraded because too expensive, and then these models, which are being used by billions of people, are simply going to overlook the existence of Germany, and then you're going to kind of become part of it far too late?
Yeah, you're right that there are several decisions that are in several directions. You mentioned this recent judgment or first opinion of an Indian court in a case against OpenAI, and we also had this decision from the High Court from England in Getty versus Stability AI. So we have kind of different and maybe contradicting decisions. So it's even more important for us to have these decisions now from the Munich Regional Court. And I think in the end, we need also a political clarification then to have a unified understanding of what is allowed under copyright law, because all these AI uses are global phenomena that cannot be regulated too differently in each country. Yes, and our focus is on licensing, as I said, because we don't want to hinder technology. It's important also to strengthen Europe as a location for innovation. So everyone wants to foster technology, but it must occur under fair conditions, and that's why we are forcing to a licensing market where human creators are fairly remunerated, and then their works can be used for AI, which is then improving more and more. And so that's the way how we could preserve cultural diversity and our human creative legacy, and at the same time promoting innovation.
You referred to Europe as a new kind of provider of innovation, not just an innovation taker, but an innovation maker. To use a slogan that's I've been like reading around on LinkedIn. It's been very famous these days. I would say this decision is very German. Like the court took it upon itself to decide, went for a decision which in other cases we've been seeing some kind of data protection trends. The German courts, even smaller courts, have been going directly to the CJU. In this case, the Court of Munich was quite confident in its decision, delivered a very, very strong argument, a very well-written one as well, I would say. Are you somehow disappointed that the case didn't go straight to the CJU, or are you happy that a German court decided on it, following a German, reasoning behind it?
I think we are not at all disappointed that we now have very quick, very clear decision in our favor. So that's very good. And the court didn't consider it necessary to refer to the CGEU because they were of the opinion that AI has to be dealt with like any other technology, and European copyright law is technologically neutral. So they made several comparisons to MP3 format, for example, where you have the compression and things are stored in other formats, but it's still a reproduction under European law. So they didn't see a need to ask a question of interpretation of European law to the CGEU. Maybe in further instances, another court will do a referral, and the federal German federal court then in the last national instance would be obliged to refer if a question is in the room and not clear to decide. But actually, we have also a CGEU referral from Hungary. This case from Like Company versus Google. The oral hearing has already taken place, and it's also dealing with several copyright relevant acts during training, reproducing in the model, and output and liability questions. So it will be very interesting to follow the developments there. I think the opinion of the Advocate General has been announced for the 3rd of September. So we will all have a look there too.
Armelle, the kind of last question to like wrap it up together. So let's look at the future of GEMA and of the authors. There are parts of these claims, but also in general of the broader collective kind of management structure. Let's think of what's going to happen next. So we said that, I mean, one case has been appealed, so there will be probably another whole process in the second instance court. Another case may be appealed. The one that's been decided on Friday may be appealed. We may even see a referral, we do not know, to the CJU. In terms of what your next steps are going to be, if you can share it of your organization, what would you say, what kind of trajectory are you going to follow? Will you just wait, or will you try and take active steps towards a different type of maybe settlement scheme, or what are you looking forward to?
Yeah, we will, in any case, be active. In the meantime, you can't only rely on court decisions, which take a long time often. So as I said, we continue our licensing activities. We have always been open to discussions with AI providers, but on the other side, there was nothing, simply rejecting, and we are not there. And we hope that with these decisions, we can now reach agreements with such providers. And the other aspect is on the political level, where we are also we are being active to resolve outstanding issues of these AI users, in particular for the subsequent use of AI content on streaming platforms and everywhere else where music or other copyright protected content is displayed. So because these cases were focused on clear reproductions in the output, but the broader question concerns any AI-generated output, which is based on the training works in any case, even if you don't have a similar output. And for all, for this aspect where subsequent use of AI content threatens to replace human-created works, we need also clear solutions to avoid this substitutional effect. And on this side, I think the legislator will also be asked for respective amendments to secure fair remuneration of authors in the AI age.
Thank you, Armelle. I really hope that this is going to be kind of the solution because, you know, it's very important to foster musical, but in general, artistic development, and it shouldn't become a battle between art and innovation. I feel like in the past, art has always meant that there had been innovation. If we just think of like the great painters of the past or the great musicians, I mean, they could become the drivers of innovation also because they had the new instruments, for example, or the new techniques. They were made available to them, and they made wonderful works with them. So it's a shame that now that we have something like AI, which is confirmedly groundbreaking as a type of innovation and technology, it's achieving great things. We really have to think: would we rather have innovation or art? It's a sad thing to acknowledge, and so I would share probably what everyone else is thinking in saying, well, it would be great if this licensing system would work and we could actually have both AI that outputs coherent stuff and great artists that work with it and have fun with it and continue to put out amazing pieces of music without having to worry that the technology will steal their jobs, which would be super sad.
Yeah, you're absolutely right. Innovation is very important, and it has always come together with creativity. Has always promoted innovation, and AI tools are very important or useful also for creators in their creation processes. So it's a great tool, but it must obey to fair rules so that it will be able to develop more in the future. Because if AI tools they rely on high quality content, and they need this, otherwise also the technology won't thrive in the future, because at the moment they are only as good as they are because they have been trained on this copyright protected material. If they don't can do this, innovation will reach a certain limit also.
Absolutely. And yeah, let's hope together that GEMA will achieve what, some very important American associations sadly haven't achieved. And like also the British case has been I feel like a huge weight on some British artists, because there had been also talks in Parliament that a given remuneration system would be put in place. Then every time kind of conversation died down. I mean, we also know that sadly the British political environment is not exactly stable right at the moment. So let's hope the Germans are going to solve it in a way. Thank you so much for this conversation, Armelle. It's been a pleasure to have you on the Legal for Tech, the podcast.
Thank you very much.
Thank you so much. And this was all from the Legal for Tech, the podcast.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.